Hello everyone, this is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna PC. Let's talk about the provisions under the Senate bill for employment-based green cards. I wanted to caution you, remember this is just a bill, it is not the law. A bill can go through several changes, transformations before it becomes the law. But the broad strokes are there. It wants to eliminate the backlog for both family and employment-based immigrations and create a merit-based system for employment eventually. That merit-based system truly kicks in 5 years, but some backlogs will be assessed against the possibility of the merit-based system as early as October 1st, 2014. Let me explain that further. So first of all, what they are doing is they are taking away the diversity, the lottery visas. Okay, people who have applied in fiscal year 2013 and 2014 will get them, but after that it will be discontinued. What's the government fiscal year? October 1st through September 30th. So if you apply in the October 1st, 2013 or October 1st, 2014 quota, you will be able to get your diversity visa. This part I like a lot. Employment-based immigration for the EB1 type, the ones that we call EB1 right now, employment-based category 1, exempts the following categories from annual numerical limitation. That means the visa is always current. There is no backlog. Even now there is no backlog in EB1, so maybe there is really not that big a deal. But at least it's a step in the right direction. And the first one, especially the first bullet point, derivative beneficiaries of employment-based immigrants. That means, right now what happens is, let's say the husband is in USA or the wife is in USA and she or he have filed their green card under employment, but their spouse was in India or France or wherever, and then the priority date did retrogressed. So now the spouse is either stuck in the home country or their green card cannot be filed until the priority date becomes current. That's a deplorable situation. So this exemption then allows the beneficiaries of employment-based immigrants to be exempt from numerical limitations. They can file 485 right away, adjustment of status right away. Aliens of extraordinary ability in the sciences, arts, education, business, or athletics. That is already there, so it's an echoing of the same provision. Outstanding professors and researchers, same. What bothers me is the incredibly high threshold created by USCIS for people of this ilk to qualify. Okay, so even though Congress wants to do to attract these kind of people and offer them green cards in the United States, USCIS can create standards that are impossible or very difficult to meet. Now, I think USCIS must bear in mind that Congress has shown a great deal of preference for PhDs and master's degrees from US universities. So the same sort of standard should be kept in mind when assessing professors and researchers or extraordinary ability aliens from other countries. We should not judge them by extraordinarily high standards. Multinational executives and managers, same thing, it's still there, no difference. Doctoral degree holders in any field. So that means we want PhDs from any field, from any country. That's what this, at least the outline seems to say that. I don't know what the bill finally says and what the final format of the bill would be, but PhDs from any field in any country. And certain physicians, again, I don't know which physicians. Hopefully we'll know more by the time the bill comes, and of course, we still have to wait till the bill becomes the law. Next is, how about those people who don't qualify under the EB1 type? So what they are doing is they are increasing the number of worldwide level employment-based visas One thing I'm not clear about is that are they also doing away with per country quota limits? Right now, whether you come from a country of 1.3 billion people like India or Vatican City with 800 citizens, you get the same number of raw green card visas, immigrant visas, which is a very strange system. But if they do away with per country limit, if that's gone, then the entire numbers of visas is thrown into the same bucket. I'm hoping that's what they're thinking. The number one point in this slide, it talks about including people who have advanced degrees and who've got an offer of employment. So basically, kind of a labor certification process, including certain aliens with foreign medical degrees. So a lot of our FMGs, foreign medical graduates, would go through labor certification process. Second category of people who are included in this are those who have earned a master's degree or higher in STEM, science, technology, engineering, management, from an accredited US institution, not from any, accredited US institution of higher education. And they must also have an offer of employment, which means kind of a labor certification process. Not sure how they're going to do it, but we will see. But the degree must have been earned in the 5 years immediately before the petition for the green card is filed. Okay. The percentage of employment visas for skilled workers, professionals, and other professionals, that's EB3 category. Right now we call them EB3 category, has also been increased, and we have created visas for those who foster employment creation. I don't know what exactly that means. That needs to be defined. We'll see how that works. And we've also created a startup visa for foreign entrepreneurs. That's very, very good. So if you're a foreign entrepreneur, you want to start your company in the United States, we have a visa for you. That, I think, is a very good step. Now let's talk about the merit-based visas. So what we are going to do is, after the law is enacted, 5th year after enactment, we'll start a point system like they have in Canada and many other countries, based upon education, employment, length of residence in the US, and other considerations. Those who've got the higher number of points will get their green cards. And there's a formula here, how many visa numbers in total and how the number can be even increased. Okay, maximum cap is 250,000 visas in this category. Now the second bullet point is interesting. What they're saying is, we will start applying the merit-based system as early as October 1st of 2014 for both employment-based and family-based cases that have been pending, employment-based for 3 years and family-based for 5 years. Okay, and also for long-term alien workers and other merit-based immigrant workers. That remains to be seen. What is other? Long-term are those who have been working in USA legally for not less than 10 years. So there's a bunch of new categories being talked about which could benefit. Because see, when they said we are going to remove the backlog, I wasn't sure how they were going to do it. This appears to be one of the components, merit-based. But what about those people who don't qualify under merit? I hope that they have some plan for that as well. That's not quite clear. Okay. Then between the fiscal years 2015 and 2021, which is about 7-year period, they keep allocating a seventh of the total number of those with employment-based visas that have been pending on the date of enactment. So they want to cut down employment-based visas to no later than 2015. We keep getting additional numbers if you don't qualify under merit, you will qualify under this this particular visa number system. Okay, it appears to me to be that. So one way to reduce backlog is 3 5-year pending employment-based, family-based cases get merit evaluation. Do we have to apply for it, or is it automatic? We don't know that yet. Okay. I'm quite sure we'll have to apply for it. Then, beginning 2015 on to 2021, we want to clear the entire backlog. Okay. This is very interesting. The second bullet point for family-based people, petitions for spouses and children of permanent residents are automatically converted as immediate relatives. What does that mean? That means spouses and children of green card holders get their green card right away, like US citizens' children and spouses do today. So we are converting the category of spouses and children of permanent residents, and children is somebody, children are those who are under the age of 21. Okay. So we are also going to reduce, like we were doing in the first bullet point for employment-based visas, we are also going to reduce the backlog based upon a formula that's not quite yet clear for family-based cases. So the same reduction will occur. In fiscal year 2022, our visa allocation becomes much more accelerated. Okay. Again, details are still sketchy because we don't have the whole bill. But this is a step in the right direction, at least in this area of the law. I would like to remind you, let me go back to the beginning. Please follow us on immigration.com. I have the links here. If you go to immigration.com, you'll see a link to Immigration Reform, Comprehensive Immigration Reform 2013, right on the very top. Twitter is immigration.com, and our app, our free app for Apple-based iPhone and iPad is called immigration.com mobile app. All of these are good ways to keep track of the latest developments. I will, of course, keep you informed as best as I can. Thank you for your time.